the recent revelations of the NSA and FBI surveillance program that was leaked a few weeks ago by The Guardian and The Washington Post. Today, we are going to focus on a specific topic. We know that most of the media is focusing on how these revelations affect the rights of American internet users. But today, I'm focusing on the rest of the billions of internet users whose private data can be stored in US server or passing through US networks. I want to see if you hear me. Yeah. Okay, thank you. I just read Ginger's comment. Okay, great. So the right question to make here is, which are the procedural safeguards that we need to demand to our government agencies that are conducting this surveillance on people in other countries, no matter where the surveillance is taking place? So as you know, I will first start explaining which are the leaks, where were the leaks, and which are the legal regime that support that kind of surveillance program under US law. But very briefly, I'm not a US lawyer. Then we will discuss which are our rights, if any, as a foreigners, of the oversight that the court have over our data being collected by the US government. And finally, we will have a discussion about what needs to be done in this case of cross-border surveillance programs when the target of the surveillance is a foreigner that is not based in the country where a foreigner outside of the United States. So to start, sorry. Okay, to start, we will start explaining the leak. So let's go to the presentation. How do I move this? So the first leak is the leak about the vast amount collection of metadata. So we know that everyone knows what is metadata. Can you reply to me on the chat? I start with that. Everyone? Okay. Fatima? Okay. So the first component of the leak targets a huge amount of metadata. This is from telephone calls originating and terminating within the United States. The leaked documents reveal that at least one company, Verizon, was ordered to hand over all metadata associated with all telephone communications originating or terminating within the United States, as well as all the calls wholly within the United States. It was reported that this program has been operated for 7 years, meaning that the US government could potentially have a historical database of all calls since 2008. Just to make a little refresh of what is metadata, metadata could be defined as very broadly sometimes. It includes the routing information, the unique mobile phone, this ID that identifies your mobile phone, the International Mobile Subscriber Identity, INSI numbers. It's who spoke to whom, when, for how long, and from where. And this, when you are mining, analyzing, can produce and can reveal very sensitive information. For instance, the government could know that if I call a phone text service at 2:24 a.m. and spoke for 18 minutes, they will know with whom I talk. but they know that I called that service at that time and I spoke for 80 minutes. They will know, the government, that you called, for instance, a suicide prevention hotline from the Golden Gate Park or bridge. But the topic of the call, the content, they won't know it. They will know, for instance, that I call a HIV testing service. Then I call to my doctor. Then I call my health insurance, all in the same hour. But they will not know what was discussed. They will know that I call my doctor, gynecologist, that I spoke half an hour with her, and that they call them Planned Parenthood. It's an abortion center, help with abortion here in the United States. But they won't know what I discussed with them. So this metadata can actually don't give me the content of the information, but it could reveal a lot of sensitive information that sometimes it could be even more sensitive than the content itself, especially through the time, if it's analyzed through certain period of time. Metadata provide a lot of context to know some of the most intimate details of our lives. And the government believe and have been believing that metadata has not so much, are not so revealing or have been protected under the law in a very lower standard. And have legal safeguards that are very weak. This not only happened in the intelligence context, but this has happened also, and just more broadly, in the law enforcement context. But now, with all the use of cloud computing, we are just leaving too much metadata that is just so much revealing that these days it requires a equiparable level of protection than the content of your data. So the first leak was all about the collection of the vast amount collection of metadata from telecom records, specifically the case of Verizon. EFF had a litigation since 7 years ago, and a similar case. When we learn about the leak, the first thing that comes to our mind is, I told you so 7 years ago, because 7 years ago, a whistleblower, Mark Klein, stopped by EFF offices, provide evidence about a huge amount of a similar collection of metadata in the AT&T facilities in San Francisco. While he was working, before he retired, when he was working there, he was assigned a task to put a splitter in a router that will just conduct all the traffic that was, the telephone traffic that was passing from AT&T cables to a room, a secret room that was handled by the NSA in that moment. EFF filed lawsuits against the government and against the companies. And a few years later, the US government adopted a law, provided retroactive immunity to companies and for conducting wiretapping without a warrant, because until that moment, companies need a warrant for conducting surveillance. So this was the retroactive immunity. The other case is still being litigated right now. This is against the government. So the leaks is really very helpful in our litigation. We hope to have something. Well, the court recently has said that they need time to think in light of the leaks, and has put our case on hold for a moment. Oh, okay. You're not seeing me? Okay, how do I do that? Ginger, I'm talking about the, are you talking about the, that's, that's okay, the video? Okay, thank you. Sorry, I cannot multitask at that level. Okay, I will try to, yeah. Okay, so that was the metadata. The second link is regarding the Prism program. Okay, great. Thank you, Tom. In this second component of this surveillance program, the full parameters of and capacity of this program, it remains unclear. But what we have figured out is that it could be like a database capable of interact directly with networks of participating companies that in the slide were Google, Yahoo, Microsoft, lately Apple, and others. It was not Twitter, it was Facebook. So in this program, I think it's an interface that could be facilitate the handover of the data to the intelligence agencies in a more automatic way, but not necessarily is a direct access as it was first reported. Well, we don't know, but it could be more like a platform where actually the company has to review the request and pass over the information. We don't have more information. Probably there are other components of the surveillance programs that will make it more massive, especially together with one of the future links I will mention. But this Prism leak is focusing only on the targeting of foreigners. And I will explain later why, because the powers under these leaks are to target foreign intelligence of internet users that are abroad, or they are taking communications between the United States and a foreigner. Various reports are describing Prism as providing access to emails, your online chat, your video, your voice, your photos, your file transfers, your search engines, your online social networks, and all the details. Because social network and cloud computing has grown in a scope, not only in the scope, but also in how frequently these powers are used. For instance, most of all the discussion about Prism have been focused on limit the exposure of US-based targets, and not so much on limited exposure of foreigners. And I will explain that why later when we discuss the powers of these systems. So let me go to the slides. Yeah. So I think I will go back one slide, and let me go back one step back to the case of the collection of metadata. Okay, and the legal powers for the first case, for the first leak, the Verizon case, is under the business record power of the Section 215 of the Patriot Act. Under these business records, as I have in the slides, the U.S. government can compel the production of any tangible thing reasonably believed to be relevant to an authorized investigation conducted for the purpose of obtaining foreign intelligence. The problem is that it seems that the government has interpreted any tangible thing as being all your call detail records and all your metadata for these surveillance programs. In the other case, in the case of the Prism program, the powers that allow this kind of massive surveillance is the general acquisition and interception power. This is the section 702 of FISA, which is the Foreign Intelligence law in the United States, or Act. In these powers, the government is allowed to compel access, possibly in real time, to information from a diverse range of companies. This second power was the one that played a role in the Prism program. And these powers targeting specifically foreigners. So it has been always, for history, intelligence agencies were able to collect data of any foreigners based outside the United States. In 2008, that law was changed and amended, the FISA Amended Act. And then they make it even more broader to include the foreigners who communicate with a United States citizen. So this is why, for many in the United States, not necessarily FF, the surveillance to foreigners has been something that everyone knows that has been happening, because this has happened since FISA in 1978, or I don't remember exactly, but several years ago that those powers were given to the intelligence agency, to the NSA, to conduct this extraterritorial surveillance from domestic soil, from the United States. And so in this power, because having always very broad, there have been things that have changed from 2008 until now. One of the things that have changed is the reach and the scope of the program, because we are now, and internet users around the world use cloud services that are based in the US. We are just putting all our data online. So the amount of information plus the amount of internet users whose data pass through US networks or are under the US jurisdiction because they are using a cloud computing service of a company based on US is just really huge. So it's affecting is FISA provided authorization to corporation? Is FISA provided authorization to corporation? Well, the interpretation we learn. So you know these laws are very secret. So you don't know exactly how they are being interpreted, because the decisions are secret and we don't have access to them. But as part of the leaks, we learn and the discussions that the director of the National Intelligence said after the leaks is that that any tangible thing needs to be interpreted as, or has been interpreted by the US government as all metadata of all calls. So we didn't know that that's how they interpreted it. And actually, we don't agree. We think that's a violation of the Fourth Amendment, and it's unconstitutional, and that's where we are challenging. Let me ask a question. I don't understand. I make a Ginger's comment. Okay. Ginger, my pronunciation of foreigners. Okay. Um, so that's, I don't know if, Stephanie, if I replied to your question. Didn't the law exist? Yes, the law exists to spy on foreigners. So the huge debate in the US is the surveillance of nationals, of Americans, because what we have learned that the process to minimize the targeting of foreigners is 51%. So this means that if 49 are captured by this, 49% of Americans are captured by this spying program, so that, okay. Yeah, this is when, yeah, I will going to explain the judicial oversight later. So in the case of the FISC, of the collection of metadata, what authorized, thank you for the question because I forgot to say that, authorized by the Foreign Intelligence Surveillance Court, which is the FISC, which is a very secret court established under FISA. That's the court, but you know the decisions are really, really secretive. It's really a very secretive court. We recently have a case in FISC. We recently have a case in FISC in which one of our lawyers in the United States, no, first there were two senators, Wyden, Udall, I think, they were pushing the Department of Justice, the executive branch, to disclassify free statements. So the FISC first is the court that conducts electronic surveillance on national security. It's very secretive. We have this case in which the Senator Wyden revealed recently that there were a FISC, the court decision that declared unconstitutional one of the programs, one of the powers. The free statement, and so he asked the executive branch to disclassify free statements. The free statement was first that the FISC has held that some executive branch surveillance, we don't know specific which ones, under the FISA Amendment Act was unconstitutional. The other one that the FISC has held that those surveillance that they have conducted have violated the spirit of the law. And then a fair one to correct the two ones. IFF FOIA that opinion, and recently after the leaks, the government executive branch was saying that it was classified, and that this is very interesting to know how the secrecy works in this FISC, because the executive branch was saying, no, we cannot disclassify that information because that's in the power of the FISC, this court. So we filed lawsuit, and finally, after the leaks, we got the results of the FISC, where they said that actually there is nothing that the FISC does not impede the executive branch to be able to release the document. It's not a huge win because the actual decision of these surveillance programs that are unconstitutional hasn't been revealed, but at least it says that it's not tied. That at least it says that the FISC, the court, is not the one who is putting barriers to the publication of this document. So this means that now it's in the power of the executive branch to actually decide to reveal it, but they said that it's secret. And more or less, what is in these documents is the process of minimization to reduce the targeting of Americans, which is the part that is unconstitutional under US law. That's why most of the debate in the United States have been focused on Americans, because that's where the unconstitutionality relies on, because they are authorized to surveil foreigners. Yes. I think I replied to both of you. Okay. It was clear, Rishab Bailey? Okay. I want to know if it was clear, the answer also to Rishab. So we have these 2 leaks, and then we learn, and this is another leak. There is another leak when we learned that this amount of information, but in EFF, even if we don't have the law in our side, because the law has authorized this surveillance on foreigners, on these powers that we mentioned below, the acquisition powers, the section 702 of FISA, which targeted specifically foreigners. So this is the power that we are interested as foreigners, the 702. Okay, so what we have seen is that there is a lot of, one of the leaks provide the amount of information that was being collected under these powers. And it was 97 billion pieces of intelligence from all the data. Okay. Okay, let me finish this part. So we know that more or less 97 billion pieces of intelligence data was gathered by this program. And this is a lot of data. And then we learned through another leak that the government was sharing, we don't know how, with the United Kingdom. Apparently, the government communications headquarters of the UK has had access of the database Prism and getting 197 intelligence reports in 2012. More or less than 2,000 reports per month, but which is still a lot. And this raises a lot of problems about many of these data might not be able to be collected under domestic law, because like in the state, you need warrants for access data of nationals, while the foreigners is a carte blanche. Everyone could do whatever they want. For nationals, they have a strong protection. Entonces, this problem of, and so in synthesis, the real problem for foreigners so far has been the lack of procedural safeguards on transborder surveillance for people who are foreigners, for a country who is doing surveillance from domestic soil. And this is something that is not in, that needs to be discussed, that needs to be a global discussion to be able to ensure strong safeguards on that front. Now, the question for one of the participants. Well, how safe is the cloud? To be honest, now with the revelation of Prism, I believe that most of the companies that we are trusting have a little loose trust. We are, and as an internet user, we are concerned, or at least I'm concerned of having my data passed to the U.S. government in a so fast way, especially in a container without a strong legal safeguards. And the more amount of information I'm storing in those servers, there is no way I could protect it, because if you use a cloud service, unless it's encrypted and you are in control of the keys, there is no way you can protect it against the government. So if you're using a cloud service, say GChat or your Facebook or perhaps your Yahoo Mail, you don't have control over the encryption. That's in control of the company itself. So they will be able to hand over the data if they are compelled to do it, because companies have to comply with it. If not, they go to jail. So we don't have in voluntary helping, because there has been they have to comply with the law, and the law is very strict. So if you don't have control over the encryption of that data, which are end-to-end encryption, then there is little way for. What do you mean, Robert, as a backup? Robert, I would like you to explain me your question a little. So there are a lot of cloud services. You know, I'm talking cloud services as a user. When you are using online service like your Gmail or your Yahoo Mail or your Google Docs, and not so much about a company having servers in other parts. There are ways where you can, for instance, upload a file that is encrypted to the cloud, and if the encryption, you have the keys of the encryption that not allow other third parties to open that file, then you are protected. But here the big problem is just the encryption is futile, because yeah, it's futile because it's there is no way you are using third party services. Yeah, okay. Any other questions? Okay, so these powers are very broad, and they are, the worst part is that they're interpreted in a very secretive manner. We have learned a little how they have been much more interpretations that are secret. We are not know. Even in those are not being published. Now the FISA, which is the court, has said, hey, executive requirement for you to publish them, because I cannot publish because it's I'm not allowed to do it because the courts have procedures that's not allowed to do so. Now the FISA has said that they are not put that impediment. A decision about which part of the program are unconstitutional, even the legal interpretation is confidential. So yeah, there is too much secrecy. A democratic, any democratic government who have so much secret programs, it's forbidden their citizens to actually do their work, which is protect, do oversight of the program. It could be easily be abused, and there is very little ways to discover unless there is leaks like this one. Lower my laptop. How do I lower my laptop? Like this? Sorry, I'm moving myself. I don't see the camera though here. It seems good. Okay, this is some of the issues that are being discussed in the spying leaks. So one of the questions that we have is what we are going to do to protect the privacy rights of foreigners. Because privacy is a universal right, and you should not be discriminated based on the fact that you are a foreigner. But the law just don't reach out that kind of activity. And this is happening not only in the United States. Other countries have the same rules, a strong protection for nationals and no protection for foreigners. And that's what the job of the intelligence agency have been. So I think that because we are relying so much on the internet and internet communications, which are global, we really need to start discussing about which kind of safeguards we need in a cross-border surveillance context, when there is a government spying on foreigners from domestic soil. The interpretation of foreign intelligence in FISA is really broad. It's really broad. It has been very much questioned. Frank LaRue even has said, in general, that when you have laws that are very vague and very unspecified, what's the meaning of national security? Usually, those vague words become a way of justify very overreaching surveillance, and it's not helpful because you are not targeting only foreign intelligence, but it's just more broader, and you catch normal internet users who are foreigners and not so much on the intelligence gathering that is needed to protect national security. So that's the big problem, that this is just go far beyond national security or foreign intelligence to target all internet users that are not that are innocent or not involved in any illegal activities. I don't know if you have any questions to this. Okay. Let me read Ginger's question, because I'm intrigued by how much data is actually available about us through metadata combined with targeted advertising. For example, as you read about the case where Walmart sent targeted advertisements to a young woman they perceive as pregnant because of the kind of purchase she made, can governments learn things like this about us with the data collected if they don't read the content of our email? Of course, and that's the rich part of the document. As long as Facebook have that data, the government could compel the access to this data. So all that is in the database of the companies could be accessed by the US government. Currently in Uganda, we face the problem of cybercrime and cybersecurity, and it's increasing on the daily basis. What is your take on those who burn the CD DVDs to earn the living, yet burning the DVDs is a crime according to the laws of Uganda, software piracy? Well, first, burning a CD or a DVD is not per se illegal. Depends on your copyright law, but usually copyright law protects work. And if you copy without authorization a work, then you might be in violation of copyright law. But there are some exceptions to that. Sometimes you can legally copy something if you are using it for fair use. For instance, in several laws, there are exceptions and limitations to copyright law, and you have to choose A, B, that allow you, for instance, to copy something if you want to show it in a class, when you're giving a lecture. So it all depends on that. But I'm not, that was the question from Robert. Now from Stephanie. If countries had to enact a stronger privacy laws to safeguard their national, would these national laws be applicable even if communication partly takes place within U.S. shores? Well, a European data protection law has very strong teeth, but usually all the data protection law has exceptions for intelligence or law enforcement. But even if they, the real protection will be if companies will collect less data, because if they collect less data, there are less data to hand over to the government. But as long as they collect the data, and no matter how strong safeguards they have, that data can be accessed by the government, and if the government compelled to access it. So far there is no law that will forbid a company to hand over. So then you would have a tension between the European Union and the US law. But companies will have to comply with their national law and hand over the data to the authorities. And it will be hard for the European Union to put a provision that force companies to violate their own national law. Or at least the company will be in between, I don't know what to do, because I have to comply with both laws and both contradict each other. So probably they have to go to The Hague. Another option could be, for instance, in the revision of the data protection directive, to put a strong safeguard to whistleblowers on surveillance. So it's to encourage people who know about secret programs on surveillance to leak information. I mean, it's an idea. But I think privacy laws protect you as long as companies collect less data. So the data minimization principle, to collect only the data that is necessary for the purpose of the business, is very important. Unfortunately, this has been interpreted, and most of the business model of all internet companies is to collect as much data as possible. So that's a huge problem. Now, I don't know if I replied to you, Stephanie, if you can write your comments. Now the next question is from Ginger. I'm intrigued by how much data is actually available about us through metadata combined with targeted. That's the same question. Yes. Yeah, Tom, now. Precisely, where does this revelation leave poor countries that cannot have enough resources to invest in spying and national cybersecurity? To be honest, spying is really cheap. It has decreased a lot. If you just see the budget of Prism, is really low. What is happening is that there are so much resources that people are leaving so much digital footprints that it's very easy to capture at the national level through your ISPs, tapping in, putting backdoors on the ISPs, depend on the country and the safeguards. So I'm not sure if that's the right question. I think the right question, I will ask it in the different ways. Which are the procedural safeguards that we need to implement, or that each country should comply to protect the privacy of all users around the world? That would be my answer, Tom. Matthew, cheers. For education, I think that civil so Matthew Shears asked, Frank LaRue makes a number of recommendations in his latest report on surveillance. How can civil society encourage governments to adopt and abide by those recommendations? That's a good question. I think that civil society have a huge work now to make sure their governments actually listen to those recommendations that are very valuable and try to implement it, whether reforming national laws or establishing more safeguards. Um, I think one of the issues is try to assess whether current national legislation are in compliance with international human rights law. And Frank LaRue report made clear what are the limitations to the right to privacy. And I think that many governments have forget to implement those limitations in the right way, because in freedom of expression, the limitations to free expression have been clearly articulated in the ICCPR itself. And so government have been very clear when civil society have been using the limitations to say, oh, this is censorship, this request is overbroad. While in privacy, those limitations have not been clear because it was not in the text itself. So Frank LaRue, by outlining which are those limitations and conditions, what is the permissible limitation test to limit the right to privacy, because surveillance is a exceptional circumstance, it should be used in exceptional circumstance. It's our duty to try to refresh the memory of our governments and tell them what are their obligations, international obligations regarding surveillance law. So I think that the next step, and just to answer these recommendations, the recommendations are just recommendations, so they are not compulsory. But I think we need to go to National Congress and we need to just do advocacy and remind them of the international obligations. That's what I believe is the next step. Perhaps something about global principles on transborder surveillance for the protection of privacy of foreigners is the next step regarding the problem of intelligence agencies spying on foreigners, because there is nothing in the law that protects that at the national level. I don't know if I was clear. If you have another question, Matthew, let me know. But I don't think I have a better answer beyond doing national advocacy and international advocacy in the Human Rights Council, promoting the results, in the URP system, reminding governments of their obligations when they fail to comply with their national obligations on surveillance, and going to the Congress and advocate for them. In developing countries, international law is more strong and it has a high, governments take it very seriously, especially in developing countries. So I think that it will have weight compared to other countries like the United States, for instance. Richva Valley. I'm not aware of the case in India to give an answer to that, but I know that the practice is to comply with a standard legal safeguard of due process. So probably if the request has been overly broad or has been unclear, that's the reason why they have failed to comply. But it's not, or the request has been made by mistake. This is why Google put in their Google Transparency report. But I'm not aware of the case that you're mentioning specifically. But probably the government has made a very overly broad request, or a wrong one, too. That was the answer for Richard Bailey. Any other questions? Okay, great. Um, I hope I didn't move too much. I'm, um, no, nothing. Thank you to you, Ginger and Stephanie, for inviting me. It has been a pleasure to be here. I will keep blogging about this in EFF website. If you go to EFF, www.eff.org, you could see the Spy Without Borders series when we are talking about the protection of privacy for foreigners. Thank you all. Bye. Bye.